sports teams, sports betting operators, fantasy sports companies, and many other in the U.S. relating to gambling laws. Please welcome Daniel Wallach. Our next panelist is Tamara Malvin. She is a partner at Ackerman LLP. She represents businesses and individuals primarily in the U.S. gaming and hospitality sectors. She's the chair of the American Bar Association Business Law Section Gaming Law Committee. Please welcome Tamara Malvin. And last but not least, our third panelist is Seth Young. Seth is the Chief Innovation Officer at PointsBet. Seth is leading PointsBet's integration of new online gaming technologies and strategies, ensuring the company is at the forefront of all of the latest trends in the industry. Please welcome Seth Young, and thank you again to all of our panelists.
Yeah, thank you guys for all being here today. We have an extraordinarily interesting topic and great panelists to discuss it. With that being said, let's get right into it. This question's for all of you, but we'll start with Daniel. I believe it's important before we get to the specifics of gambling laws here in Florida that we talk about where other states are in the process, where Florida fits into that, and where Florida is actually in relation to other states around the United States.
I'm sorry, I couldn't hear. Can you say that one more time?
Yeah, absolutely. I wanted to talk about, before we get into kind of the details of where Florida is at, kind of where other states are in the process and how Florida relates to that in where we are in the process.
Okay, sure. You know, we're about roughly 2.5 to 3 years after the Supreme Court decision, which made it possible for states to consider whether to legalize sports betting. So in that short period of time, we've gone from just Nevada, the only state which allowed single game sports betting as under an exemption to pass, but to now we're at 25 states plus the District of Columbia, and another 15 or 20 have bills pending during this legislative session. And Florida, while it's one of the most populous states and one of the most obvious no-brainer states for sports betting, it has several challenges in trying to get over the finish line. You have some complications, compact with the Seminole Tribe of Florida. And then 2 years ago or 3 years ago, the voters approved an amendment to the state constitution, which made it more difficult to legalize made it more difficult to legalize casino gambling, not sports betting. And there's some school of thought as to, well, where does sports betting fit into the category of casino gambling for purposes of Amendment 3? I've written articles for Forbes explaining why sports wagering is not subsumed within the casino gambling constitutional amendment. But I think that that adds an additional layer of complication to the debate. So we have the constitutional issue, the compacts, and of course, the political dynamic in Florida of, we're like so many years talking about gaming expansion, and the short legislative session in Florida, which is only 60 days, we've come up short on pretty much every type of gambling expansion for the last 4 or 5 years. So sports wagering does get caught up in that somewhat.
Seth or Tammy, do you have anything to add on that?
I'm happy to jump in a little bit. And before I start, I want to say a couple things. Thank you guys for having me on this panel. I want to start at the outset by saying I am a law school dropout, so I will never turn down an opportunity to speak to law students that are up and coming. Very exciting times. And it's a pleasure to be joined by Dan and Tammy, two folks I know very well, and the gentlemen in suits who are putting me to shame this morning. But look, I think to dovetail off of what Dan said, to say that there are several challenges in Florida is an understatement. It is one of the most politically complicated states to pass online gaming or sports betting because of the stakeholders, a lot of cooks in the kitchen. So when you ask the question about what the landscape looks like across the country, Dan is bang on. There are 25 states that have legalized sports betting. It's easier to talk about the states that don't have any legislative activity than it is to talk about the states that do. And in the states that do, you see very, very different structures. And what you look at, from our perspective as an operator at PointsBet, when we go to get into a state like in New Jersey or in Illinois, typically we have to partner with a land-based casino, or we have to partner with a racetrack or an existing gambling stakeholder. And the reason that things have evolved this way is that back in 2013, when online gaming, online casino was introduced in New Jersey, you had all of these new companies, these online gaming companies coming into the market, and the brick and mortar casinos are already known, they're licensed in their state, and they said, okay, well, we really want this thing. Online gaming, it's going to be incremental to our revenues. You're going to find a new kind of customer and so on and so forth. You know us, but you don't know these companies. So why don't you license us? We will look after these businesses. And fast forward now 7, 8, 9 years, you have this model that has been duplicated in other states. And that's because these groups in Florida, like the Seminole tribes or the racetracks, they're very politically influential. They tend to have a strong voice as employers and drivers of tourism. And in other states, the stakeholders may differ, but the underlying concept or mechanics of how this kind of evolves is the same. So a lot of different structures. You can kind of handicap which way each state is going to go by understanding who the stakeholders are, what the political sentiment is, what the people want. But honestly, in Florida, it's one of the most difficult ones to decipher. And I'm really looking forward to hearing what Dan and Tammy have to say about this one today.
Yeah, I'll just, a lot was already covered, but I'll just add that, taking a step back, the way that the states legalize and then regulate gaming of any kind, there's some form of an agency that's a state agency that oversees those operations. And I'm going to put the tribal gaming aside because they're an entity of themselves. But when it comes to commercial gaming, whether it be sports betting or online gaming, as Seth just referred to, you have a state agency that oversees the regulations. They push regulations through and they oversee the entities that are operating. And so there's the element that usually gets ignored that we just haven't touched upon in terms of the consumer protections and knowing the customers, anti-money laundering, all of those concepts that are also responsible gaming, all of those concepts to protect the consumer and to help the state to regulate this highly regulated industry. That's a lot of times why you see kind of the way it's unfolding is the existing operators that, as Seth mentioned, the already operating brick and mortar casinos getting licensed to do this new vertical. It makes it easier in some respects because they've already shown that they know how to do this. They're responsible. They've been working within the regulated industry, and the agencies know that they can do what they promise that they can do, and they can quote, babysit these new companies coming in with the technology. So just wanted to throw that in as another aspect of the very dynamic conversation to keep in mind.
Yeah, and I wanted to touch, Daniel, on something that you said about the Florida Constitution and it being one of the kind of roadblocks potentially for legislation here in Florida. In 2018, for the audience, the amendment granted Florida voters the exclusive right to decide whether to authorize the expansion of quote unquote casino gambling in the state of Florida. I know, Dan, you mentioned that you don't believe that sports betting falls under the category of casino gambling. Can you talk a little bit more about what goes into the determination for what casino gambling is, why sports betting is not casino gambling, and why it's a potential impediment to getting legislation passed here in Florida?
Wow, that multi-part question
I can go one by one
of some of my first year final exams. Are you sure you're not the direct descendant of Professor Monroe Friedman from Hofstra University School of Law? Wow. I'll try my best.
You guys are going to want to buckle in for this one.
Well, first of all, this is the perfect question when we're talking about Florida sports betting legalization, and it's a law school symposium. That's probably the best time to get into the weeds of the Florida Constitution and its interplay with the legislative ability to authorize sports wagering. That's a great law school, sports law and gaming law question that is really well suited for a law school discussion. Just to kind of underscore why this provision is so important. It's not so much what it grants. It grants voters control over casino gambling. It's what it takes away that's equally important, which is the state legislature's ability to not only pass a sports betting statute the ordinary way, which is to introduce a bill, have it heard by committees, voted on the floor, and then signed by the governor. This strips the legislature of the ability to impact or authorize sports betting, not only as a matter of statute, but in many states, including Florida, there are two ways to amend the state constitution, or principally two ways. Citizens can start a petition drive and gather signatures and bypass the legislature to put on their own amendment to the Constitution without any approval from either the governor or the state senate or state assembly or state house. This measure prohibits the legislature from even putting on its own ballot question. I think in California, last year, the state legislature was attempting to create a ballot question for sports betting by having it be approved by 2/3 of the state Senate and 2/3 of the state Assembly. That power, which exists in almost every state, that's no longer available for state lawmakers. So if sports betting were to fall under the umbrella of casino gambling, the only way it could ever be legalized is through not just a ballot question created by the legislature, but it would have to be another citizen-led initiative to gather signatures, spend all this money to create a marketing campaign, and it really makes the prospects of sports betting legalization sort of between slim and none if it falls under the umbrella of casino gambling. So let's take a look at the definition of casino gambling in Amendment 3, which is now codified in, I think it's Article 10, Section 30 of the Florida Constitution. Casino gambling has a very specific definition under that provision. It's defined as the type of game typically found in a casino, measured as of the date of the adoption of the amendment, which was November 6, 2018. And then the second part of the test is it has to be has to fall into the categorization of Class 3 gaming under IGRA. Class 3 gaming encompasses pretty much any type of gambling game which is house banked, slot machines, poker, sports wagering, parimutuel wagering on horse races, highlight, greyhound race wagering, basically any and all types of casino gambling, sports betting, horse race wagering. So there's no question that sports betting falls within Class 3 under IGRA. So that part of the test is satisfied. So it ultimately comes down to, does sports wagering constitute the type of game typically found in a casino as of November 2018? And in the article that I published, I think I did it back-to-back years in Forbes in 2018 and 2019. At the time of adoption, there were roughly 40 states that had lawful casino gambling in the United States. And of those 40 states, only 6 of them had casinos with sports books. So I took the view that sports wagering was not typical of a casino throughout the United States in 2018. And then taking a look at the provision even further, casino gambling is defined not only in the way I just described, but there are basically 12 lines of examples of the types of games that are casino gambling. And I don't want to go through the entire list right now, but it's like slot machines, house bag games, baccarat, blackjack. Essentially, all the games that are listed are the types of games that are endemic to a casino environment, that are played and decided primarily within a casino. The exclusions under this constitutional amendment for horse race wagering, highlight, and dog racing, those speak to those are gambling situations tied to events which are external to a casino environment. So the point of departure between sports wagering and casino gambling, in taking a look at all of those examples, is that in every single case we're talking about a game of chance in which a random number generator or some kind of randomized event that's totally beyond the control of the bettor decides the winner or loser. Sports wagering has been classified in every single advisory opinion issued by state attorney generals as a game that is predominantly skill-based. So sports wagering and casino gambling differ in the underlying character of the games, in that sports betting, game of skill, casino games are games of pure chance or games of predominant chance. Second point of departure is the location of the underlying events. And as I mentioned earlier, casino games, if you ever go to a casino and play dice games, card games, slot machines, all of it is within the four corners of the casino. Sports wagering entails betting on the outcome of events that take place hundreds of thousands of miles away from a casino floor, and almost inevitably never taking place on the casino floor. There are very few sporting events which are held in casinos, unless we're talking about maybe some of the boxing matches in Atlantic City in the 1980s, 1990s, Michael Spinks against Mike Tyson, but that's more the exception rather than the rule. And then for those of you who like to really dig deep and do a significant amount of research, I've taken a look at some gambling studies that have been published by the federal government. There was the NIGC study in 1999, and then before that, there was a 1976 study that was commissioned by Congress. And both of those studies examined the landscape for gambling across the United States, and throughout the literature, casino gambling and sports betting are dealt with and described as separate species of gambling. And if you want to get a little bit closer to home, a few years ago, the Florida legislature commissioned a study by Spectrum Gaming to examine the history of gambling in Florida and the prospects of legalizing different forms of gambling. And that report also described and assumed that sports were separate species of gambling. And then, of course, there's the icing on the cake. At the time that Florida, I don't mean to take up so much time, this will be the last point for now. At the time that Amendment 3 was under consideration, there was another bill floating in the legislature that was introduced by, I forget the representative's name, but it was out of the Florida House of Representatives. It was an identical legislative counterpart to Amendment 3, which almost was word for word the same exact language of putting gambling in the casino gambling in the hands of the voters exclusively. The measure that passed, that made it to the Constitution, doesn't mention sports betting. The measure that was introduced by the House member, word for word, the same exact provision, but his measure includes sports betting within the definition of casino gambling. So you can't say that the other group didn't know about the possibility that they could include sports wagering. So the inclusion of sports betting within the definition in the measure that failed and was introduced at the exact same time is very telling as to whether you would consider sports betting to be part of casino gambling, when the sponsors of the petition had every opportunity to include sports betting, had a parallel bill to look at, and yet made the conscious decision not to include it. Everyone's just stunned, speechless. I don't know. Is that...
No, I'll chime in here. Look, there's so much to unpack. I could listen to Dan all day because he's one of the smartest people that I've ever met in my entire life, and seems to have a memory like nobody I've ever met in my entire life. It's absolutely incredible. I'll say a couple of things. Look, I'm not a lawyer, so I'm going to be sandwiched between the lawyers who can opine on what is right and wrong. But what I'll say is that, I think Dan's interpretation is subjective. It's not to take anything away from what he has to say. It's just to say that it's one opinion. And I think if you ask two different lawyers the same question, you can have two very different answers about how gambling can be treated in Florida. A purely technical view of what's on the books and what's not is one thing, but there's a huge difference between understanding law and understanding politics, and politics influence legislation. And in Florida, it's really more forward than in most other states in terms of how politics can drive the evolution of sports wagering and largely online gambling within the state. From a political perspective, and I guess, even a cultural perspective, sports are treated very differently than gambling. traditional gambling. So when Dan says that this is more of a game of skill, that's true. It's also gambling, but it's also skill-based, right? It's one of those games where you have the ability to influence the outcome with the relative skill that you put into it. When you make a bet, you don't think you're going to lose. You believe your bet's a winner. And if it wins, well, skill-based. If it loses, well, gambling, right? So I think for that reason, when it's so prominent culturally, sports, it really permeates the fabric of everything we do on a day-to-day basis. It's easier to treat than online casino. Now, I bring this up because online casino really is where the vast majority of revenue will be driven from operators. Online sports betting, it's a big quantifiable black market. In Florida, more than many other states, the market is much bigger relative to, say, West Virginia or Delaware or Montana, much, much larger. But it's also not a single needle-moving piece of revenue for any real significant stakeholder within the state of Florida, depending on how this is structured. Online casino, on the other hand, can be a very big needle-moving revenue opportunity. So prior to when I was at PointsBet, I worked for the Mashantucket Pequot Tribal Nation up in Connecticut, and they operate Foxwoods. And I was in a position where I was asked to testify in Connecticut on the expansion of gambling, both sports and online casino. And it was the position of the tribe that sports betting was a Class 3 game. It was the position of tribes in many other states that sports betting is a Class 3 game. Different stakeholders obviously have different views of whether or not that's true. What I can also say, or at least this is my opinion now, I wouldn't take this as fact, is when you look at stakeholders within a state pushing for one thing, and I'm certainly not pointing any fingers by any means, so I don't want to be taken out of context, you can say, if you have a grip on gambling in your state and a grip on gambling politics in your state and a grip on being able to influence the process, if you really care about one thing, but something else is very important to other people, you're going to use that as a chip to get what you really want. So in this case, the question has to be asked, what does Florida really want? What do the stakeholders in Florida really want? Is it sports betting, or is it something else where they can leverage sports betting and make it painful for the state to bring it forward and bring this out of the black market? What is more important to the state? Is it a world without a reliance on revenue sharing from casino gambling, or is it more investment from sports betting operators that are hopeful entrants to the market? These are questions that are difficult to answer. And I think a lot of people will have very different opinions about how to answer them. But to dovetail off of everything Dan said, you have the legal part, you also have the political part, and the political part is going to drive the legal part, regardless of what we think is right or wrong.
So I'm going to preface what I should have said this before, but this is my standard. I speak for myself and not for any of my clients or my firm's clients. So now that I've said that, because especially this is a law school symposium, I think one of the things we've kind of skipped over is almost like the building blocks to this conversation. And we're taking a lot of things for granted. And I just wanted to take a quick step back to touch upon a few things. The conversation about sports betting really came to a head around, leading up to the PASPA Supreme Court case in 2018. And basically what that was, there was a federal statute that really held back the individual states from having sports betting within their borders. Now the PASPA case moves forward. The Supreme Court finds that it's unconstitutional, and it leaves the federal issue. It is no longer an issue. The states can now go and decide what they want to do within their own borders. We haven't discussed, and we probably will get to the fact that that was not the only federal law in play, and there are still other federal laws that have an impact on sports betting as well as gambling across the country. IGRA, which Dan touched upon, is a 1988 federal statute that classified types of gaming into 3 classes. And the reason that not the reason, but one of the consequences of the classifications is that there are certain types of games that fall, I'll say games, wagers, bets that fall within each category. And depending upon which category they're in, that impacts the type of gaming that occurs within your state, depending upon who the stakeholders are. So now when we come back to Florida, it is a great breeding ground for learning how to be a gaming attorney, or just understanding whether it's online gaming or sports betting, because we have, as Seth mentioned, a lot of stakeholders. We have parimutuel facilities around the country. Parimutuels are horse race, dog race, and high live facilities. Dog racing, when, you know, Dan mentioned, and we talk about all the time, Amendment 3. Well, there was also Amendment 13 that got rid of dog racing within our state. So now we're primarily talking about horse racing and highlight. However, those dog racing facilities are allowed to continue to exist. And why, if they can't have dogs racing? Well, because the parimutuel facilities in Florida so parimutuels are governed by Chapter 550 of the Florida statutes. The parimutuel facilities are also allowed to have card rooms, and in those card rooms, they have poker, which is a non-banked game and falls under Class 2 of IGRA. The poker in the card rooms is regulated and allowed under Chapter 849, which is actually within the criminal statutes. But the parimutuel facilities around the state are allowed to have card rooms. Most of them have them. That's a huge source of revenue. In South Florida, in Dade and Broward, as many of you probably know, we also have the addition of slot machines in the parimutuel facilities. Slot machines being under the IGRA classifications, a Class 3 type of game, means that because we also have tribal gaming with the Seminole tribe and the Miccosukee tribe, they can also have the same type of game that's offered. So they also have slot machines in the state of Florida. The Miccosukee tribe does not have a compact with the state. They have slot machines because slot machines are lawful under Chapter 551, but they're only lawful within Dade and Broward. That's a point of contention, and there's been a lot of litigation and conversation about that in other parts of the state. And part of that conversation is actually what precipitated in Amendment 3 with the concern that other, or not concern, but the conversation that other counties around Florida were looking into having referenda and trying to legalize slot machines at their facilities, their parimutuel facilities in those counties. So extremely dynamic. And I just kind of wanted to break it down a little bit because we've got Florida statute, we've got Florida Constitution, we've got a compact with the Seminoles, we've got an Indian tribal compact to deal with, we've got issues of federalism and federal law that have an impact on this conversation and what we're talking about today. And I just wanted to kind of give you a little bit of that background. And also Seth mentioned online gaming, and that's one of those things that I've been saying, and I'm not the only one. When the sports betting conversation got really, heated, so too revived online gaming. I mean, the iGaming conversation, and kind of say iGaming or online gaming, either one kind of works, potato, I guess. That conversation has been going on for a while, but I think that it kind of fell flat. I can't explain why, but I really believe that this conversation about sports, and Seth, feel free to jump in and tell me I'm wrong. But I do believe that the conversation with sports betting revived the online gaming conversation. And maybe part of it is just a new generation of adults. Technology is completely taken over. There's a huge difference in the way we live now versus even just a decade ago. When the iPhone first came out versus today, a lot has happened. So the sports betting conversation is in itself its own conversation for, discussing legislation and constitutional amendments. I mean, it's certainly its own conversation, but we can't ignore, just from, a practical standpoint, you really can't ignore the online component because it's going to be part of the conversation. And we're seeing across the country, some states are legislating and regulating only brick and mortar sports betting. Some are jumping right in and saying online is okay. Some are saying we'll start, we'll do a mix of both. And I think, Seth with PointsBet, they've kind of, got all of, across the board all the way. But that will then turn into, if it hasn't already, okay, well, if we're online with sports betting, because also when it comes to, again, as mentioned, sports betting is not a huge moneymaker. I mean, certainly it's a great, it's a good revenue stream, but it's not, slot machines are going to make a lot more. And I think that's maybe also like a misnomer. People think, oh, sports betting, it's this huge, multi-billion-dollar market, but there's a lot more to it. And so, the margins are much slimmer than other gaming. So as Seth said, online casino, if you can have that gaming, you're going to make a lot more money potentially, probably. And then you've got the black market. So you've got people saying, I get these calls all the time. Well, I can do it online. I went to this website. They let me do it. Well, it doesn't mean it's regulated. It doesn't mean it's legal. Maybe it's okay for you as a consumer because you're, one person, but I certainly wouldn't tell you to be one of the operators and try to step foot in the country. So there's just so much to discuss. It's really dynamic. It's so interesting. And going all the way back to what Dan said and Seth's comments about what Dan said, saying that it's subjective. A lot of this ends up in litigation and before appellate courts. The PASPA case ended up in front of the Supreme Court. So as a litigator, I find it that much more fascinating because in a way, ultimately the law might be created by the judicial system and not, it might have its beginnings in the legislature, but there's a really good chance, especially in Florida, that there's going to be litigation and there's going to be a panel of judges that make the determination as to what something means and how it should be interpreted.
Daniel, I know you wanted to respond to something real quick.
Yes, I concur. I want to dial back to Seth's issue where he said all of this is somewhat subjective, and I think he's right. And when you look at this issue from a litigation perspective, or even just analyzing constitutional language, there's another set of principles that come into play here. And by the way, I think we do need to talk about the sports betting bills that have been introduced. We're looking ahead to potential legal challenges rather than talking about some of the exciting possibilities that are right before us in March and April. And we might be getting close, but putting that aside for a second, it's very important to understand the principles of constitutional interpretation that govern how you read this language. You don't read them in a vacuum. In essence, this prohibition or this voter control of gambling is really a restriction or a limitation on legislative authority. That's really what it is when you cut through the words. It restricts the legislature's ability to pass any law that's considered a casino gambling authorization. So as a matter of well-established constitutional principles, and I've looked at this issue in Florida, California, and New York, it governs all around the country. The principle that applies here is that when courts look at this, the restrictions on legislative authority are strictly and narrowly construed. That's a rule of interpretation that applies in Florida, California, just about every state. So you don't read these words like you're reviewing it de novo. It's, if you're an appellate lawyer, you have different standards of review. This is not de novo review where you're looking at it through the prism of which one is more likely to be correct. The benefit of the doubt and ties go to the legislative authority. So the two rules that you would need to think about as you approach an analysis of that issue is that restrictions on legislative authority are narrowly and strictly construed, and any doubts as to whether the constitutional provision applies is resolved or should be resolved in favor of legislative authority. These are principles that are a matter of Florida case law. You can look those up. So when you look at it from the substantive aspects of it and how you define casino gambling and sports betting, that's certainly one layer of the argument. The other is looking at those concepts through the prism of well-established principles of constitutional interpretation, which I think make the prospect of a legal challenge to any sports betting law a very uphill battle, to put it mildly, and one that I think would meet, would meet with defeat in my view of it. Depending, and I think that's, if this goes before a lower court judge, an appellate panel of the Florida Supreme Court, I think the challengers to any sports betting law are going to really have their hands full trying to persuade a court that under these principles of constitutional interpretation, and given the distinctions between casino gaming and sports betting, that sports betting fits within Amendment 3. So that's the challenge that they face. But I think notwithstanding that, this is the first time that I feel that we're getting really close to legalized sports betting. I know I say that almost every year in every state, but the comments over the weekend from Governor DeSantis, for whatever issues you have with him, he's certainly trying to do his best in bringing the stakeholders together, because this is really the number one issue in Florida, not the Constitution, but the disparate interests of competing stakeholders. You've got the Seminole Tribe of Florida, you've got the pari-mutuels, and then within the pari-mutuels, you have different factions that want different things. With the Florida Lottery also in the background, there's the debate over who should be the regulator. One sports betting bill calls for the state lottery to oversee sports betting. The one that I assisted on, which was introduced by Representative Chip Lamarcker, calls for the division of pari-mutuel wagering to be the regulator. So there are a lot of issues to sort through. And the difficulty in getting this over the finish line is that Florida has a very short legislative session, while states like New York and Massachusetts can go for 6 months to a year. We're limited to a 2-month window in which to pass legislation. And that's the major obstacle.
I might just jump in and add one thing. And if you're going to take anything away from what I say, maybe it's this, in this whole conversation. I mean, we're talking to the next generation of lawyers and people who can grow up and influence public policy and do good civil service work. And there are two ways to look at legislation, I guess, particularly through the lens of gambling for this one. One is, if you are the states, are you looking to regulate an activity because it is necessary for the protection of your constituents and consumers? Is it a safety issue? Is it a regulatory issue? Or is it an effort to drive revenue for public policy initiatives, which can also be very good, but those are two very different ways of looking at how you craft an overarching governing structure for an industry. Either it's about the money or it's about the people. And that can wildly change how legislation is adopted, what the structure is for businesses that can or can't invest. On one hand, you may have arguments from some that say the best way for a state to drive the most revenue from sports betting is to run it through the state lottery, where the lottery can invest the vast majority of those revenues into public policy initiatives. In my view, that is a fundamentally flawed approach. It does a lot of things wrong and not a lot of things right. And the other way to look at it is that you have open investment from qualified entities to grow a market, channelize a black market into a regulated market, have a larger direct and indirect economic impact, create jobs, and also provide, ironically enough, more consumer choice, which leads to better consumer protection. It's no longer a race to the bottom when you have a monopoly. So I think that's really important as you guys graduate and you get into the world, thinking about just the technical reading of law and what you're told is right isn't always pragmatism. It isn't always common sense. Have a healthy skepticism about what right and wrong actually is in terms of how you lead your lives and how you want to see the world evolve. I think it's an extremely important message.
Thank you guys. Very valuable insight and input from all of you. Mr. Wallach mentioned some of the Senate bills that have been introduced, and I'd like to start with Ms. Malvin here. Our next question is about Senate Bill 392. It was introduced this year, and assuming that sports betting is not casino gambling under the Constitution, I was wondering if you could talk to us about a realistic timeline that Florida could expect.
So I'm smiling because I think I'm probably the most skeptical of the three of us. And again, I'm going to be fairly careful with my answer because of what I prefaced my answer with before. I think that we have a lot of interests in Florida that slow the process down. I'm not saying slowing it down is a bad thing. There's no judgment in that statement. Where you have states that don't have existing interests, things can move a little bit more rapidly. So one of the things that we didn't mention, or one of the, I don't know, maybe an insight, is the fact that there are interests that are not gaming interests that also have a say, or have desire to have a say in this conversation. We haven't mentioned them, so I'll mention them now. The sports leagues and teams, and in particular the stadiums, and also Disney. And this was all very much public record. We mentioned earlier Amendment 3, the very known backers of Amendment 3 financially, and I guess also ideologically, it was Disney and the Seminoles. So, we need to also remember that, while yes, there are many parimutuel interests, there are tribal interests in the state that they're all, they offer some and operate some form of gaming, and they want to have a stake in the next vertical of gaming that the state allows. There are also other entities that are going to have want to be part of that conversation that are not necessarily gaming entities. There's also the anti-gambling folks. And when we're down here in South Florida, we kind of have, I think, a little bit, we live in a bubble. We live in a very populous, geographically long state, which also is something to consider when thinking about if something is going to happen, when and how. We're not all the same across the state. There are different, from a citizen perspective, there are different interests and desires and concerns and thoughts. So how we think in South Florida is not going to necessarily be the same approach in, the Panhandle or in the middle of the state. There are different, there are different employers, it's a different industry in different parts of the state. So with all that said, if some form of legislation passes, if it's going to involve commercial gaming, meaning that it's not, it might involve tribal gaming, but if it's going to involve the state being the regulator overseeing it, so that it's a commercial game being offered by whether it's a stadium or a parimutuel operator, it doesn't just, you don't just snap your fingers, okay, the legislation passed and now we can operate here. Then there's going to be a process for rulemaking, creating the regulations. If you follow the news around the country, just saw an article about Tennessee is taking its time and have, maybe some people are being a little bit critical of what's going on there. I certainly can't speak to that intelligently because I'm down here in Florida, but I can say that there are different timelines in different states in terms of passing the regulations, and that as difficult as it is to pass a law, it also then becomes difficult to create the rules and get the regs pushed through, because it's just another layer, it's another level of conversation, stakeholders coming together and desiring to create the best scenario for them. When we talk about sports betting, we're talking about existing entities in the state, and we're also necessarily talking about outsiders coming in. I'm going to say outsiders, but PointsBet, companies that are just chomping. I'm not going to speak for PointsBet, but I imagine that there are companies that are chomping at the bit, pun intended, to enter into the Florida market, because we don't have interstate liquidity in sports betting. So imagine coming into Florida. It's already a populous state. We've got lots of sports teams here. We've got great tourism, huge draws into the state. It's a great opportunity to open up. And there are also lots of stakeholders outside of Florida. Some of them have already started to make their, preliminary deals with existing entities in the state. So all this is just to kind of give you background and to say, I can't necessarily, guesstimate a timeline, but it won't happen overnight, that's for sure.
Do any of the other panelists want to agree or chime in here on this before we go to the next question?
Sure, I'll just chime in to say that I think it's very difficult to handicap the timeline in Florida for this one. I think a lot of people want it, but because there are so many cooks in the kitchen, as Tammy mentioned, we've been talking about, so complicated from a stakeholder perspective. Your guess is as good as mine.
Okay, so
yeah, I'm sorry, I muted myself accidentally. Just adding to this,
please continue.
Another complicating factor is the Seminole Tribe's former, or I guess gaming compact with the state of Florida as a result of a court ruling several years ago. The state of Florida was declared to be in breach of the tribe's compact exclusivity for, because they're allowing these house banked card games under the guise of sort of a rotating dealer to take place in all these, card rooms throughout the state. And as a result of that controversy, the Seminole Tribe, have suspended making their revenue sharing payments. That has roughly approximated $300 million annually to the state of Florida. So those payments are now gone. So regardless of the budget situation the state is in, step one is trying to cut a deal with the Seminole Tribe through an amended compact, because one of the primary objectives of the state or of the lawmakers is to try to bring that money back in. And the tribe and state lawmakers have been negotiating, or the governor has been negotiating with the tribe to try to come up with a broader compact that might give the tribe more, included games, table games, and in return, the tribe would pay, not only the $300 million, but I think the revenue sharing payment would be $750 million annually. So that is priority number one if you're the state legislature, because that's where most of the money is going to come from. And without tribal participation, the thought has been that there's just not enough money in sports wagering to forfeit or to compromise the tribal revenue share. With his bill, I don't know if the class has had the benefit to compare the different bills, but there are two primary sports betting bills that have been introduced in the legislature. There's the lottery bill that was introduced by Senator Jeff Brandes, which would tax sports betting operators at some low tax rate. I don't know if it's 10% or 8%. It's a very low tax rate with licensing fees that are 5 figures. That alone, if that passes, wouldn't generate the kind of money that would more than make up for what you're losing without tribal participation. Representative Lamarca's deal is a little bit more participation by professional sports venues. And we're not talking just the NHL and NBA, Major League Baseball, but it's also Major League Soccer, lacrosse teams, every professional sports venue of, major venue within the state of Florida gets the opportunity to offer retail sports betting, and they get a mobile skin. On top of that, the tax rate, and Seth, don't shoot the messenger because I didn't suggest this. Representative Lamarca proposed a 22% tax rate, modeling off of bills that he's seen in Massachusetts and some of the other states like tax rate and 20% tax rate in a mobile-only environment. So he's raised, or he's included, a tax rate that is among the highest in the country, as well as created a licensing fee structure, a one-time licensing fee of, I think it's $7.5 million per license holder. And when you add up all the sports venues, all the pari-mutuel venues, which total around 30, plus the tribal operators, you're looking at somewhere in the neighborhood of 45 discrete licenses. And at $7.5 million, that's a one-time guaranteed payment to the state of $300 million in year one before you even tax so much as $1 of revenue. So what Representative Lamarca are a couple of objectives in his bill that might be worth emulating in the bill that eventually passes. And I think this week there's going to be a major gambling package introduced in the state legislature that will probably carry all the momentum on sports betting. But what it's trying to do is to look at my structure here. This tax structure, this licensing could guarantee the state of, what was it? I'm fading.
You're going in and
connection's
out.
not good. Okay. Anyway, yeah, here I'm going in and out. Anyway, the Lamarca bill would, I think, promise the state or guarantee the state almost as much, if not more, than what the Seminoles are offering. So I think that's the higher tax rate and the higher licensing fee structure in the Lamarca bill. So it just shows that there are two parallel measures, and what the bill ultimately looks like that will pass. I think we're not close to the finalized version of any bill.
Thank you. So I think we have time for one more question before we get to Q&A from the audience. So this one's for you, Seth, and can you discuss, as much as you feel comfortable and as much as you are allowed to, the steps that operators interested in obtaining a license to get in for sports betting and gambling here in Florida have to take, assuming that legislation is passed, or even before the legislation is passed, before getting a license here in Florida?
Yeah, Zaid, I'd love to be able to answer that coherently, but the truth is I can't. We don't know the steps that we have to take to enter Florida until there is a clearly delineated rules about how we do enter Florida. And I think this comes back to what we're talking about the structure of legislation. In legislation doesn't happen by accident. You have interested stakeholders that weigh in on what the legislation should look like. Us included, in many different states around the country, and many other groups who have their own opinions about what this should be. So when we talk about having all of these cooks in the kitchen in Florida, this can go in 4, 5, 6, 7 different directions on us, which will dictate exactly how we'll have to enter the state. I guess to demonstrate what we might do in, I'm not going to say a normal state, but in a state that has already passed sports betting legislation, like in New Jersey is a good example. There are the commercial casinos and the racetracks, and in statute, what has happened is that these casinos and racetracks have all been issued the ability to get a master license and then sell sub-licenses or skins, as we refer to them, to groups like PointsBet, FanDuel, DraftKings, Barstool, etc., where we will make a commercial relationship with one of those racetracks or casinos, and that casino or racetrack will then hold the master license with the state. We still have to get licensed, but we are effectively sheltered under that group that is already the known licensee within the state. And then from there we operate. And typically those commercial arrangements vary, but typically they have a revenue sharing component where the partner that you would have in Florida or any other state will benefit from the upside of your operations if you're successful within the state and you invest well and you can actually turn a profit. So look, in Florida, it can go so many ways. There are ways obviously that we'd like to see it go, but what it comes down to honestly is we're a very well capitalized business with arguably the best product for sports betting in the market. We're a product-led organization. We create a lot of jobs. We take care of a lot of families. We'd like the opportunity to invest in Florida. This is happening anyway in the black market. While we fight about what this should look like, money continues to be funneled offshore to operators that have no duty of care standards for the consumers. So for us, as a responsible operator with great tech and a value proposition, great pricing, promotions, et cetera, we would like to be everywhere we can be. We want to invest. We want to create jobs. There's a lot of things we can live with outside of that. Of course, you're not going to enter a state if you can't actually make money. It is still a business. But there is nothing wrong or anything that we're opposed to about funneling tax revenues for public policy initiatives. If we can count the business that we're doing for good, that is a huge bonus and part of the reason I love being part of this business. So I'm not sure that really answers your question directly, but it is the best way I can answer it today.
Tammy, did you have anything to add on that?
I think really the answer is to look at other states to see how they've done it. And each state is allowed to do it in their own way. And we're kind of seeing every state has its idiosyncrasies. Some are more similar than others, which creates great opportunities to be a compliance attorney. In, all of these companies are expanding. If you go on LinkedIn, you see there are a lot of new job opportunities with, all kinds of companies that maybe initially, historically were brick and mortar companies, and now they're finding their way online, or from, or from the companies that are purely online and just expanding from jurisdiction to jurisdiction. So I guess that's a plug for all of the students here to know there are going to be new employment opportunities in places where those opportunities didn't exist when I was graduating. So, to say, what's it going to take to enter Florida, I have to, say, yep, Seth is right. We don't know the answer to that. We can kind of guess that it will not go too crazy off course from what the other states are doing, in that there will likely be, we can forecast some potential things that might occur. Potentially, there will be, under some, I guess it really, it's a hard question to answer because it could go so many ways. If it's just a lottery, if the lottery is the only player here and it's being, put out throughout the state via the lottery, it's going to look very different. But, or if it can only be, tribal operated, but I'll give just kind of a general idea of what it could look like. There will be an agency that oversees this new form of gaming. And those who are interested in being able to operate it and offer it to their customers will have to fill out an application with that agency. And they will do background checks on those companies. They will, the application will probably be pretty thick. They'll have to do disclosures, financial disclosures, ownership disclosures. There will very likely be an initial licensing fee that will be fairly high. There will be a barrier to entry, which actually can sometimes be, yes, it's to bring money into the state coffers, but it actually also kind of helps with consumer protections as well. You're not going to get a fly-by-night company that has no capital to actually support. You don't want customers making bets that then the company can't pay out if they win. But then after that initial licensing fee, I would assume that there would be a yearly licensing fee, probably less than the initial one. It could be that, it just kind of depends on what the structure is, but that's kind of a general, notion of what it could look like, where there would be a reapplication every year, or it would be more of like a renewal every year, where they would pay something to renew their license. If the state allows multiple skins, then you would have to get approvals for those operators to be licensed as, the vendor, or however the state defines them. And you would see a lot of, we're seeing it a little bit already in anticipation, but you'll see some kind of activity between the, let's say the existing entities that are brick and mortar facilities are allowed to offer it, but they're allowed to have online skins. Or they want to partner with an existing sports betting operation because they don't know how to set lines. They don't do that. That's not their business. So they bring in a partner. You're going to see some kind of contractual arrangement. It could be there could be just purely an arm's length transaction, and it's for a certain amount of years. And if things work out, they renew. If it doesn't, they find a new partner. You could have some kind of, M&A activity. There could be, some kind of marketing deal, especially if we see that the stadiums are allowed to offer it. There's so many different ways that this can kind of, and that's less legal and more, business. But where the legal comes in, of course, is who's going to paper those deals. But, as Seth said, because we don't have, the law hasn't been passed. And, that's the first step is, do we like what the law, the laws that are, the bills that are being put forth in front of people to determine how it's going to look. That's what the law is going to say you have to do. And then from the law will be, whole bunch of regs and a whole bunch of rules and things that will be at the administrative level. And that will then take more time to determine what the forms look like, who's in charge, who oversees. And so without the initial law to know what we're basing off of, it really is hard to answer that question. But maybe I gave a little bit of a little bit of an understanding as to what it could encompass.
And maybe it would be helpful if I can give an example of just a handful of structures that we see in the country, and because Tammy just did an amazing job running that down. Let's start with Oregon. Oregon was one of the states that was grandfathered in because they were grandfathered into PASPA. So they technically were able to offer sports betting. They just never really did. So they ended up introducing a model through their state lottery and circumvented the legislative process. So they have a single operator that is serving them technology, and the lottery is the front-facing application that people can play sports betting on. That's one model, and that is consistently underperforming most other models throughout the country. I have no qualms about saying I think it is an absolutely flawed model, and anybody giving advice to a legislature to go with that model is giving very bad advice. The second model, it's somewhat similar, is Tennessee, where it's also run through the lottery, except it's not a single operator. So Tennessee doesn't have an existing gambling stakeholder landscape. There's no casinos there. So what they did was they used the lottery as their regulatory body and said, okay, if you are a sports betting operator, here are the rules. You'll pay us, 20% tax rate, $750,000 annually. You have to hold 10% of every dollar that you take, which is something that doesn't exist in legislation anywhere in the world. But lotteries aren't in the business of losing money, so it is in there for a reason. Another flawed take, but it is what it is. So lottery, there is no cap on who can operate so much as you qualify, you get vetted, and you go in. The third model would be the tethered skin model, but even then you fork it. So you have a concept of in-person registration, which is how Iowa started. So there are a number of casinos in Iowa. Each casino in Iowa was able to commercialize 2 skins, so they can make 2 commercial relationships. And in order to sign up for a site in Iowa, at least for the first 18 months of legislative activity of the market being live there, you had to go to the casino that was sponsoring your application. So for us, we worked with a casino called Catfish Bend in Burlington, Iowa. Burlington is 50,000, 60,000 people, maybe. It's not Des Moines, which is the most populous city. And for that reason, location becomes very important for the first 18 months of operations. If you're in a city with 50,000 people versus a city with 500,000, if you're tethered to a group that has a $500,000 person addressable market, you're going to do better. Right. So that disappeared at sunset after 18 months. And that is political. That is the reason that goes forward is political. It's not based in any kind of pragmatism whatsoever. And then the last model is more New Jersey or Michigan. But there's a slight difference between the two. In New Jersey, you have a concept of multiple skins, but it is a very well-regulated market. And in Michigan, where you have 15 stakeholders, it's a single skin environment. So there are actually more companies interested in investing in the state than there are licenses available. So we're not just competing as a business when it's PointsBet or any other operator to make a deal in a state. You're also competing, so to speak, on the structure of the state, which dictates how you can actually enter the state. So that's why it's such a hard question to answer. And those are just 4 or 5 examples of how it has evolved in other places throughout the country.
Great, I appreciate it. It's been great insight from all 3 of you for the entire panel. I think it is the perfect time to send it to some audience questions. So if you are in the audience and you have a question, you can use the participants tab to just raise your hand and I will call on you so we don't have a bunch of people.
I have one question.
Go ahead, Josh.
Yes, Tammy, Dan, thank you so much for speaking today. We all really appreciate it. So yesterday during the name, image, and likeness panel, I touched on this as our last question. Sports books such as PointsBet have agreements with some universities, such as the University of Colorado, where they are sponsoring the school and there's marketing material out there. Yet none of these college athletes yet are able to see any of the money that's being bet on them in college sports. So do you foresee a future where college athletes will be able to partner with sports books such as PointsBets and utilize their name, image, and likeness. And if an athletic department can partner with a sports book, why shouldn't a college athlete be able to do so?
So I think you asked some excellent questions, Josh, and how I'll answer it is this way. We're very proud of the agreement that we made with the Colorado Buffaloes, and it started a great conversation about education instead of abstinence, so to speak. I think it is largely forgotten, and we constantly remind legislators, the general public, et cetera, that betting on college sports is happening whether it's a black market or a regulated market. So there is no actual basis in reality to ban betting on college sports other than to turn your head around or put your head in the sand and just pretend it's not happening. It's happening. So a lot of groups will fund studies for responsible gaming. And for our part, we're a very socially responsible operator. And we're also working to educate the students in Colorado that, look, this is a real thing. This exists in the world, whether it's legal or it's not legal. And you should at least understand what it is so you're not taken advantage of in any way, shape, or form. Now, we know the NCAA is I guess, formally opposed to sports betting at this moment. We also have seen bills in certain states around the country sort of advancing that name and likeness discussion. So I don't think it's my place to weigh in on how I feel about it, especially on behalf of this company, so much to say as, college sports are very popular in the US. I mean, it is March Madness right now. It is consuming probably all of our lives, at least mine at this moment. And if it wasn't regulated, or even in Florida right now, what we're talking about, there is no legal option to bet on sports. I will guarantee you that anybody who's interested in betting on college sports in Florida was able to do it in 5 minutes through a black market site and through cryptocurrency or otherwise, or with their local bookie. So we want to channelize that. We want to give people a trusted place to do this, where they're not worried about whether or not they'll be paid, whether they're not worried about how their money can move in and out of this, and have to look over their shoulder. There's no credit or anything like that. So that's our focus. Our focus is in providing the best product to people where there is a demand, and that's how I'll answer that, Josh.
Okay, assuming I have a stable internet connection now, I'd like to, weigh in on this topic very briefly. It's a major quantum leap forward to go from allowing college betting in a state to having the NCAA and the colleges and their bylaws allowing college students to endorse gambling and to be paid for it. So the students are going to be subjected to their university bylaws, NCAA rules, and I don't think we're quite there yet. As progressive as this industry is becoming, and now the leagues like the NBA, Major League Baseball, the professional sports leagues filed lawsuits, and we're trying to prevent the legalization of sports betting by relying on the PASPA law for so many years. Eventually, times change, the laws change, and you want to sort of ride the money train, so to speak. But I think colleges and universities will ultimately or eventually stand to benefit. And I think that's where the athletes can indirectly benefit, because if the sports betting companies are paying sponsorship fees and monies to the university for having the branding, maybe that's a vehicle in which some of that money could be shared with the students or devoted to student programs. But I don't think we're going to see the day where Trevor Lawrence is sort of a product endorser for PointsBet while he's playing college football. That's not going to happen at any point within the next couple of years. And I think we're years away from that, because when you're talking about college athletes, it's an age group that is within sort of the sweet spot of problem gambling, 18 to 21. These athletes aren't paid. There are legitimate concerns that college presidents have, that the NCAA has, about the corruptibility of collegiate players. I mean, every major sports betting scandal, match fixing scandal, has its genesis and roots in a college player throwing the game. The point shaving scandals have been predominantly, focused on college basketball. City College in the 1950s, Rick Kuhn, Boston College in the late 1970s, the Arizona State scandal in the mid 1990s with I think it was Hideki Smith, who owed money to somebody, and to pay his debt off, he shaved points. So there's always going to be an elevated level of concern when we're talking about college athletes. But that being said, I think it's counterproductive to prohibit wagering in collegiate games, which some of the states prohibit betting on the in-state colleges. And I think there are several bills in Massachusetts, one sponsored by the governor and one sponsored by Senator Eric Lesser, which would become, if enacted into law, would be the first collegiate-wide ban on sports betting. It wouldn't necessarily be limited to the local colleges, but you wouldn't be able to bet on any collegiate sports. And all that's going to do, I think, in the long run and in the short run, is benefit the adjacent states which allow betting on college sports, or drive into the black market. So I think having a prohibition on collegiate betting is not exactly the correct solution or a proportionate response to the perceived integrity issue. I think allowing the betting is probably the best solution for providing transparency and a mechanism for monitoring the wagering activity, so that you can actually have an ability to ferret out suspicious wagers and learn about these types of activities at the earliest possible time. If you relegate it to the black market, you minimize the opportunity to learn about it in real time. But that's a different subject than the notion of compensating athletes for endorsing gambling products. We're not quite there yet, and we may never be there during this decade or this century.
Yeah, I'll jump in just to quickly say that I don't think this is necessarily a conversation that's limited to college student athletes. This is really a conversation about athletes as a whole, in terms of where, and I'm certainly not the best person to talk about it in terms of, experience and backgrounds. But, I imagine yesterday you guys had a very good conversation about this topic. But there is a conversation about, who owns the data and how that data can be used. And that's not limited to the college sports, that's the sports across the board. So I think this is a much more, this is a conversation that if we have this panel 5 years from now, we will probably have a lot more to say. And there were probably, maybe not 5, maybe that it might be 10, but it's a conversation that's being had, and we will see how it unfolds. I imagine the professional sports world will unfold a little bit more quickly than the college sports, because of the added layer of just student protections as well. But this is certainly a conversation that involves athletes across the board.
Alexis, you had a question?
Yes, hello everybody. My name is Alexis. I'm a second-year student at FIU Law. Just wanted to thank you guys all for taking the time out of your day to come speak to us today. My question is, as a second-year law student, we learn a lot about civil procedure and the Constitution and the rule of perpetuities, but gaming and sports betting really isn't something covered in most classes. So I guess my question is, how did you get into this industry? Is it something that you've always wanted to do? Is it something that you fell into?
I want to take this first, only because you referenced civil procedure, and it's a great story. So I was sitting in my Civ Pro class at St. John's University School of Law. And this was back in, 2005, maybe late 2005, 2006. I always wanted to be a lawyer. Everything I did growing up was, I'm going to be a lawyer. I'm from New York. It's just what we did, right? You're a doctor or a lawyer of failure from my family. And I didn't like needles, so I figured law was the best way to go about it. When I was 13, I started my first business by accident. When I was 15, I got threatened with a lawsuit from a group that was asserting the IP rights to a domain name that I owned. And this was back in the late 90s. So this wasn't settled as a matter of law. And I thought that was extremely compelling. So fast forward all the way to my Civ Pro class, I was starting to play a lot of poker, and I was playing a fair amount of poker while in my class and doing quite well. I get called on in the Civ Pro class. Mr. Young, can you tell us about so-and-so case? And everybody in the corner where I'm sitting knows exactly what's happening. And I'm autopiloting. I said, yes, of course I can. And about 30 seconds later, the whole class is silent, still looking at me. And professor says, come see me after class, and asked if I wanted to be a lawyer. I said, yeah. And he said, do you want to be a lawyer right now? And I said, no, you're probably right. I guess not. So I packed up, moved out to Las Vegas, and grew a business that I was running, and sort of the rest is history. You meet a lot of really interesting characters in this space, sort of fell in love with the fact that every day is not the same. I'm not the real sit behind the desk guy and just kind of look at Excel or write a Word document. Got to be out there, talk to people, and do some interesting things. So when you're talking about a dynamic industry, it's interesting. And for this one, when I started, this was, in my view, one of the last big industries to really resist the internet actively. And over the next few years, as I learned more and more about it, I understood why that was. Now, did I think it was going to take 15, 16, 17 years to get to this point? Absolutely not. But am I glad I stuck it out? Absolutely am. Very exciting time to look back when I started in, let's call it the Wild West days, where there was no career path. You just had to be interested. And now there's a career path. This is why I was so keen to come on and join you guys today and just kind of share what the experiences are and a little bit about this, because now you have this incredible opportunity to be a part of a massive multi-billion-dollar emerging industry that's going to create a ton of jobs in just about every single vertical and permeate the fabric of our culture, touch everybody's lives on a day-to-day basis. Super exciting stuff.
Yeah, I got started kind of accidentally. I was practicing law in Florida for a large firm in Fort Lauderdale, Becker and Polyakov. Many of the students in the audience might be familiar with the law school, but I think I was close to 20 years into my career, 22 years into my career, had never handled a gaming case or had done any sports law. I was, pretty much a commercial litigator with a heavy emphasis on appellate law. And then I got a case in 2012 representing the Isle of Capri Pompano Park racetrack in a lawsuit against Gulfstream Racetrack, Gulfstream Park, which later became one of my clients, by the way. And that I guess scratched the itch for gaming law, and I was so about that case that I began a blog, and I took blogging from 2012, 2013. It's like 8 years ago, and that catapulted me into an entirely new career, because all I ever wrote about during my days of writing for my law firm blog, and when I was doing the rounds of media interviews, is I became obsessed with the sports betting controversy or the litigation involving New Jersey against Major League Baseball, the NCAA. I was sort of an analyst on that case, and from that spawned a career as a gaming lawyer, believe it or not. So there are so many different paths, and I say this every day. If it wasn't for Ray Lesniak or Chris Christie or Ted Olson, I probably would be still at Becker and Polyakov and wouldn't have a podcast. I wouldn't be on this webinar today, and I'd have absolutely nothing to do with sports betting. I owe my current career entirely to writing about an important, cutting edge new topic within the gaming industry. And if you're in law school, I think one of the ways that you can differentiate or distinguish yourself, I mean, my story is probably, one of the more bizarre ones, because you don't get to change careers that many times and have something like that happen in your 50s. But what it underscores is that if you're right and you utilize your time in law school, not just to network or build your credentials, but to take a serious novel expert on something important, that could pay dividends later in your career. And I didn't get to where I was today. Not that I don't know where I am, but wherever I am wasn't because of networking. it was through industriousness and trying to have mastery on a topic of importance, and taking advantage of that opportunity and working my ass off on it gave me the credibility and the confidence to make a transition into a new field. So it happened purely by happenstance and a little bit of luck.
I don't want to take any credit for Dan's career, but there was a good 6 months where just about every week I was telling him to quit his job and just do it, because he was out there and he's a great voice, very opinionated, and really backs up his opinions with a lot of thought. Right or wrong, there's you could see that it's coming from a place of being very creative, and it's the advice that I can give is dovetailing that. If you're passionate about something, find a way to be an expert. And nobody can take that away from you. You can do whatever you want. I know it sounds cliche, at least in my position, I can say, 16, almost 17 years later, some people can look at this and say, okay, this happened overnight. Didn't happen overnight. You got to love something. You got to put in the work. But if you take the time to do it, you'll live your life on your terms and really enjoy what you're doing every day.
So I guess I'm maybe a mishmash of the two of them. I grew up in the horse racing industry. I always knew I wanted to be a lawyer. I actually thought I was going to be a prosecutor because I'm a child of the O.J. Simpson trial. And I don't know. I was about 9 or 10, I think. I can't believe I actually watched that. I don't know if I would allow my children to watch it, but it was a different time in the 90s, I guess. But that had a huge impact on me. There were all these male lawyers. There was one top-notch female prosecutor who just, I don't know, she made an impact on me. So anyway, fast forward, and I go to college, still want to be a lawyer, end up going to law school. But I knew I wanted to be a litigator in some way, shape, or form. It started off thinking, I want to be a prosecutor. Well, I went to University of Miami for law school. I did my third year CLI, is that what? Yeah. With the state attorney's office, and quickly decided I don't want to be a prosecutor. So I think I'm going to go to work in a law firm. And I really started off in commercial litigation, very focused on just general contract disputes, some personal injury actions, but in federal court. And as I grew into myself as an attorney and got a little bit more confident in my litigation skills, I also had the opportunity to work on some appeals of the litigation I had worked in. So I got to kind of, see the cases from beginning to end. And I started to kind of realize the fact that law school, it doesn't teach you to be practical. Clients will tell you that when you're the lawyer, you are the least practical person in the room. You think of the very worst case scenario that can happen. And if lawyers were in charge, no deals would be done. But we analyze situations. We have the perspective to be able to say, it's that kind of, I don't know if you guys ever did that, create your own story, or you could go down one path or go down the other. And you can almost play that chess match. I'm going to keep using metaphors, to kind of think like 3 moves forward. I like that about it. I like being able to, analyze a situation and say, this is what could happen. This is also what could happen. Now you guys can, let you guys decide, are you willing to take that risk? What's the analysis here? Which avenue do you want to pursue? And I think, my experience is limited to that litigation side of things. So it also gave me a really great ability to get into more regulatory analysis and statutory analysis, to be able to say, okay, laws are written, you think they're clear in the moment. Years later, a new situation arises that maybe wasn't anticipated when the law was written. And, you can do something else that wasn't necessarily thought of at that time, or there's going to be litigation and we're going to argue over what this means. And I find that to be fascinating, that the law can really be created or shaped or formed by litigators. I mean, that's exactly what happened with the PASPA case. And I really followed that case closely. At the time, and still my practice was very much focused on hospitality clients and the parimutuel clients that I do work for here in Florida. And I flew up to DC, as did Dan, and I got to go into the Supreme Court and watch live. I was breathing the same air. I could, see the hair fibers of the justices. I mean, it was the coolest experience. This is kind of a nerdy lawyer thing, but I think I'm in the right crowd here. Every lawyer, student, or graduate should take the chance to go to DC and see at least one Supreme Court oral argument. Whatever, it's just so cool. But anyway, so I was there in DC, watched the oral argument, and then we all kind of made our guesses and bets as to what was to come. I think most of us had a pretty good feeling about it, and then a few months later, about 6 or so months later, the ruling came out, and that really just solidified for me so strongly that litigators and appellate attorneys can create law, can shape an entire industry. And it also solidifies the point that my colleagues here have made, that find a focus you're interested in. I grew up in the horse racing industry. I've seen how that industry has shaped and how the parimutuel industry has really changed from when I was a child to today. Generations grow and have different interests, and industries have to grow with them, and we're seeing it happen. We've got like that front seat view to it. So however you enter upon something, I say make sure it's something that really interests you. You find that niche, you find that special thing that makes you, it just makes you more passionate about it. You're naturally going to be able to pull it off. And then don't be shy, make friends. I'd say Seth and Dan are two excellent networkers. I think I like to say I am as well. Make friends. You never know. You can help somebody out. They might be able to help you out. And it's nice to just work with other people. Feel like you're truly with in a community while you're working.
Thank you. I think it's important advice and great advice for all of us here. I know Seth has to go in 1 minute, so I want to just thank all three of you for an amazing panel. I think we learned a lot about it, and we appreciate you guys coming, and we hope to have you back in the future for maybe this time next year in person.
Thanks, everybody. Enjoy the rest of law school. Don't drop out.
Thank you, sir.
Thank you.
Thank you. I'm really grateful for being able to be part of this. Looking forward to in person.
Absolutely.
Likewise.
Thank you, everybody. Thank you, Josh.
Thank you for joining us.
Thank you.